Hello everyone, welcome back to part 4 of this miscarriage of justice of our son Farhad Said. This is just a continuation for us to present our case because we just don't believe it. Our leaders, the court, because all of those complaints we made, beginning with the Supreme Court of Australia, Chief Justice, Ombudsman, Royal Commissioner, Judicial Commissioner, Human Rights Commissioner, and Attorney General himself. They ignore these evidences by expecting us we're going to sit down and accept this, which is we know completely it's wrong. If you wanted to go with the evidences, there is no evidences our son why he was convicted in the first place. As we already stated before in our videos, we present how Farhad pleaded guilty, what was said in the submission, and what was on the proceeding in a previous video. If you haven't watched them, just please do so because you have to understand. But because the time is already over, and we don't think the investigation it was already been done long time ago. As we made a complaint to Office of Legal Service Commissioner about the misconduct of Adam Huda, the lawyer. They want 6 months. They want 6 weeks. We gave them 6 weeks. They want again 4 weeks. We give them 4 weeks. And then 2 weeks time, we receive an email to say they're going to close the file because there's too many complaints. The complaint was so big, so they're going to close it. Our reply was, you have money, you have resources, you have power to do whatever you like. But in case, if the defense of Farhad, he wanted himself to go in prison, he should not write a submission to say Farhad, he was innocent. He agreed. They took back the complaint. They say, but now it's going to take 6 months for them to reply. I said, okay, no problem. They have the power. We wait for 6 months. After 6 months, they say the decision it was already been done before. Nothing's going to change. That's how it is. We complain about the judge. 5 months he took to reply and come back and say, look, the judge is already resigned now. We are not going to investigate anymore. We don't know what that means. It means our son, he has to come and stay, finish his sentence, and there's no justice will be served in our side. We believe because of our background, because we don't have money, but if you want evidences, the evidence is in our side. If you want documents, it's in our side. And the thing is, we didn't know all of this before until we got the file when Farhad wanted us to appeal to the High Court. So we just prepare some questions so the public can understand this case. And there is no way, like any country in the world, which there is a justice, and the parents or the caretaker or the guardians, whoever, know these evidences and will sit quiet just to be afraid to say like, look, well, they've done this one because they wanted to protect the community. But the community is the people who live a blameless life like ourselves. We need to be protected. The people who have a low self-esteem. As we said before, we are not against the police. We are not against justice of this country. We are not against anybody, we are against this miscarriage of justice of our son. He has nothing to do with this terrorism offense. There is no element to put him in. Summary of fact, it says itself, Farhad wasn't part of it. The judge knew it. Farhad is not to be sentenced for the conspiracy because in the Crown case, he's not part of it. So we just made a few questions. This time I just put a little bit notice. I'm not pretty good writing proper way, but I'm going to put the questions. Few questions for the defense and few questions for the Crowns and few questions for the judge. So everyone can understand what we are saying. It is not something for us we made up. It's something we read. And this has happened here in Australia in a Supreme Court. So any leaders who listen to this video and then to come and say otherwise is not what you are saying. It's about the evidences. In the law of Australia, you cannot be convicted until you have the you have evidences to convict people. So without going through the details of the other co-accusers, because in this file there is nothing on Farhad, to be honest. Everything is about everybody else's. We will come to talk about it, the entire case, in the next post. If we are not gonna get a response of anything, of something can be done. There is no need investigation. Things are very straightforward and very clear. It's not something you can want to sit for a long time or hire, cost a lot of money. It's a common sense, and the law is in our side. But if we do not gonna get justice, we will never gonna stop until all Australian and African background of someone like myself, we don't want to live in a stage like it, to be worried we could be arrested anytime. Offense can be created and then we can be convicted and then we sit quiet, because this is for the good of ourselves and everybody else in a justice. So the question we wanted to put in the defense is Farhad was not part in the Crown case of conspiracy. How come the defense, Mr. Huda, advised Farhad to accept the plea bargain? Because in the submission itself, it said this document appear to be true, but not necessarily so, to commit act of terrorism. They appear to be true, but it's not true. Just because somebody accept the plea bargain, still the law says they have the Crown, they have to come and prove what's went wrong here. So Farhad, how come he was not part of the conspiracy, and then his defense advised him to accept the plea bargain? This is the first question. The second question is, Farhad did not plead guilty to be part of the group or violence ideology. Why did the defense went to concede it out of agreeable fact? Is it agreeable fact is Farhad he has to agree in one way or the other? But they went to concede it in the court on the proceeding on the 5th of the 10th, 2017, without Farhad's knowledge. Even they said, like Farhad denied, but Your Honor just put it in and conceded. So is that legal to do it, to go against this agreeable fact? The third question is, did Adam Huda advise Farhad to plead guilty, or the accuracy of information collected? How can he go and say Farhad plead guilty for accuracy of information collected before the offense was not even created, of the violence and to involve guns? Because does he has the foresight to know what is going to come in this case? Because this is what the judge has put in. As Farhad plead guilty in a second offense, so accuracy of information collected. So we wanted to know exactly, and we wanted the public to know, how did he knows accuracy of information collected? Is this to cover things up? But this question, no one will answer it. But we just wanted the public to know exactly what went wrong in this case. And our leaders is not something they could ignore. Because for us, as I say, we don't want to live worried and feel like any time we could be arrested and then to be chucked in prison. You know what I mean? Offense could be created and then there's nothing you can do because you are in Australia, because we believe we are part of this. We don't involve in any kind of trouble. So do we all, African background here, to live in worried, to know these things could happen to everybody? Because you cannot say you protect a community. You protect a community for somebody who is who? Low self-esteem? Somebody who can't even stand, somebody who doesn't even know what has been done in his case? It's ridiculous. So now we just ask the Crown the question. Why didn't the Crown reply to the submission of Farhad? And they decided to submit its other co-accuser submission. In fact, it was a different evidences and different conducts, completely different. Can you believe, like Farhad he has his own submission. They put it from the defense barrister, which is, I believe, that it says everything about this case. It says everything, everything if you want to know about this case is in that submission. But for somehow, judge cancel it, and then he uses someone else's and convict him with the evidence of someone else, and they went to court of criminal appeal, use that submission of someone else, like as he was Farhad who did that. So why did the Crown did not reply to Farhad's submission? If it's true, he was involved in a group. So obviously he wasn't. That's why they went to use someone else. The second question for the Crown is, do the Crown, you have the power to tell the court do or don't? It's a very simple. If you tell her, yes, you have the power to tell court do or don't, it means there is no point even to go to the court, because you already have the power to instruct the court to believe or to say whatever you wanted to say in order to convict people. Because in the submission, general submission of each and everybody, which is you involve Farhad in it, you said very clear, the court, they should not believe these people who they plead guilty. They should not believe they don't have a violence ideology. So instead of going there, if you have evidences, you could go and say, look, Your Honor, this is the evidence of Farhad Saidi, this is the evidence of someone else, this is the evidence of whoever. But you didn't do that. You just put it in and be commanded. So do you have the power to do that? You know, if no, why you did it? Why you tell the court not to believe these guys that do not have a violence ideology? The second question is according to the Commonwealth Public according to the Commonwealth Public Prosecutor, they signed the plea bargain charges day before Farhad accepted. Isn't that a common sense? Farhad, he has to agree first because he is accused, and then they can sign the charges. But why did they sign the day before? How can you call that a negotiation? And the charges itself will say Farhad, he was there on the 17th, on the 18th December 2014. But in the same time, they forget. In other co-accuser case, they put in details what happened on the 17th, on the 18th of December 2014, when Farhad, he was not there at all, according to the police informant. So this is ridiculous. This is how things you could see they have been done inside out, upside down. It doesn't matter. Just we have to put in the paper, because Farhad, he doesn't have a parents. He's African background, low self-esteem, and he doesn't have anybody. So they can do whatever they like it. This is ridiculous. You cannot do this, man. So this is some of the evidence. The questions are like, you will never gonna answer it, because even if you attempt to answer it, you're gonna ruin everything about everyone else if you try to involve Farhad in this offense. And this happened in the Supreme Court. We have a question also for the judge. We're gonna record specific, special for the judgment and the judge. If nothing is gonna happen, we're not gonna say when, but until Australia understand this case, it was miscarriage of justice without reasonable doubt, according to the evidences. So the judge on the judgment never mentioned about Farhad's submission and the proceeding, what was saying on the proceeding of Farhad. Like example, his own defense, they told the judge, look, Farhad, he wanted himself to go in prison. He's already prepared. Can you sentence him a maximum penalty? He never said this, judge, because you know why? If he say the judge, he will look, I don't know, I don't want to say it, because the judge you're going to sentence just because the defense wanted. Where is the evidences? The defense of Farhad, they say this, they requested the court, to put in the court, Farhad, he wanted to go himself in prison. But judge never said it. So he covered it up to look like, Farhad is guilty of something. So this is we just don't believe it, man. There is no one who can reply this. When did Farhad plead guilty for another offense of accuracy of information collected? It's clearly stated on the document. The document is not appear to be true, but not necessarily so supporting the violence jihad. So when did Farhad plead? Did the judge came up with this? Or did Adam Huda made Farhad to plead? He knew the future? Or there was a conversation, for example, there were discussion? Because our son, he didn't even know. Farhad, he doesn't even know about his case whatsoever, what has been done. Only what he was put in by his defense, this is what he believed. This is the things. So, second question for the judge. Is the judge's job to design the case or to look at the facts? You know exactly where I'm going with this, but I'm not going to put much explanation. I'm just waiting until the judge. Is it the judge's job to design the case or to look at the facts? I'm just going to leave it with there until the time of the judge comes. The charge of the judge, he sentenced Farhad. Not only he wrote 2 documents. He said he wrote 2 documents. But in a Commonwealth public prosecutor charge, Farhad, he wrote only 1 document, which is, it's amazing. There was no handwriting of Farhad. I'm repeating on the summary of fact. He wasn't part in a Crown case. So when did Farhad plead guilty with the 2 documents, which is they just come up on the judgment? We're just going to leave it. We know these questions, no one can answer it. Because even if you attempt to answer it, you are making clear Farhad is innocent. You cannot come and deny, no one can, because it's documented. And then you know what's the mistake you made about this case is, you went to do all of this, you documented, and then you send us the file. Just because we are not well-educated people, we did not learn about criminal law in Australia, but this is far and beyond. I know our background, we're not good in laws or anything like that, but sometimes when things are out of control like this, it cannot be done. So we just put the request this time before we go to the judgment, or to disclose exactly what happened in this case for everyone else, because that's what the Farhad's file is. Not we copy from anybody, it is in Farhad's file. That's what we read, so we can talk about it. This is forever. We put request to Attorney General, please look at this case, because no one can answer this question. It's very obvious. Not just because people they say, oh, he was convicted. He was convicted. We do not want to talk about the entire case about it, but we believe we have every right for us as a people, as a human being who have a feeling to, you can release our son. Because this is a request for Attorney General, because everywhere we made a complaint, they refer back to Attorney General. It does not matter, you are not on power on that time when they were charged, but we know who was on power. But because this is Australia, and they say we have to fight to get justice. So we already said, ask these questions, and so everyone can understand what we are saying. It is true, not fabricated, well documented, and it is embarrassing, actually, this happened to be done for somebody. Man, there is no element, whatever you can connect our son in this case. He's already suffered enough. And then not only that, we got bullied. Because we wrote to our leaders, and we thought Farhad is going to be released on parole on the 25th of the 2nd this year, 2023. And guess what? The judge who convicted him, he was on the chair to deny him parole. And the reason is because he doesn't have the address where to live. Man, he used to pay $400 a week. Wife was pregnant. His life was start to take off. He went to demolish all his house. Marriage was broken. Everything was turned upside down. And then now you blame him. He doesn't have the address. This is the address in our house. He can come and leave us because he grew up here. We are the only parents he knows. And then the other thing they said, oh, because he did not do, psychologist said. What's the psychologist say? Farhad, he need a verb and interaction to improve his low self-esteem, but instead they went to lock him up in Supermax, 23 hours a day incarceration. And then you come and blame me, we're not going to give you parole because what? You didn't do what psychologists say. Or because you have anxiety, or you have all of this. You cause all of his anxiety. So he's already suffered. And now, for the first time, he's been moved. Now he's mixing with the other inmate. So we hope everything, it will go okay for him. Nothing serious will happen. We will continue to struggling until someone listens to us. And one day, this case, it will take off. Because when we start to involve everybody else, that's how we will get attention. So we don't need all of this. We need our son to be out. We're not going to say when we're going to release the next video, but we're going to say it about the entire case and the judgment. Because so many things have been said on the proceeding of others to prove our son was innocent, and there was no case actually to come to all of this. Thank you very much for your time. Hope to speak to you soon, but we just repeat, we want an Attorney General as a first law officer to look at this case and release our son. Take this matter to the Parliament and then let them know we investigate true what his uncle say it is. This should not happen in Australia. Thank you.